Yes, sir, I can hear you. I hope
Okay.
my video is visible to all.
Yes, sir. Guys, welcome to another day of our law internship. Sir is here. I hope you're all on board with whatever we have studied so far. Sir, I hand this over to you now.
Sure, sure. Thank you very much. Good evening, everyone. Today we will be studying about NI Act, Negotiable Instrument Act. Okay. I will share my screen with you all. Give me a moment. I was busy in some meeting due to which I was unable to join. Give me a moment. So everyone is aware about the legal notice. Who sent this legal notice? What is legal notice? And when we serve a legal notice to anyone, can anyone tell me? कौन कौन बता सकता है मेरे को?
When we send a notice to the opposition party to convey some message.
Okay, good. Anyone else?
So, it's
Yes, yes,
usually
yes,
sent to
Rajni.
the advocate. It's usually sent to the lawyer of the letterhead when we write to capture or replace something like the address, name, something.
No, no, no.
Actually,
You are
if
wrong.
I tell you just
It
Sir, a
is.
legal
It is.
notice is usually sent to the lawyer of or advocate of the defendant to acquire some necessary information which is not available to the plaintiff.
Anyone else?
So the
और कोई
lawyer,
बताएगा?
the notice can also be sent as a warning.
Like a warning.
Sir, how is
Suppose.
plaintiff different from the defendant?
चलो, I will answer that also. First, we are on legal notice. First of all, the legal
Excuse me,
notice
sir.
is yes, yes, say yes, Aradhya.
So, like, I wanted to add something for legal notice.
Yes, yes, say.
So, sir, legal notice is basically a drafted document that is given to a party, like, to basically for numerous reasons.
Hmm.
Primary reasons being that to call a party to court to for some case to proceed for some case or to draft a notice for doing something.
हाँ, we can say that basically legal notice is sent by an advocate. ठीक है वो, लेकिन जो लीगल नोटिस वो एडवोकेट जो बनाता है वो ही सेंड्स दैट नोटिस टू अ पार्टी, नॉट टू एन एडवोकेट. The reply of that legal notice is sent to the advocate who has sent that notice, or we can copy that notice to the advocate as well as to the client. Understood? So notice is basically a thing, a legal document which is given by a party to the another party through a counsel who can be an advocate for demanding something, whether it can be money, whether it can be possession of a land, whether it can be in. Sometimes we also send a notice for getting divorced. We that so and so wants to get divorced from you, so we are giving you this much amount, or we can mention that thing in that notice, or we can simply fix a meeting. You are hereby called upon. So the last para is a call which is being made in the legal notice for demanding something from the party to whom we have addressed that notice. Understood?
Yes.
Basically, if I will tell you in a layman language, suppose कि आपकी कोई आपके पेरेंट्स ने या आपने एक्स ने वाई को कोई लोन दे रखा है, सपोज 1 लाख रुपीज का लोन दे रखा है, तो हम क्या करेंगे? व्हाट विल बी द फर्स्ट रेमेडी? अगर हम केस डालने जाएंगे उससे पहले हमारे को, इट इज नॉट अ मैंडेटरी इन रिकवरी मैटर्स टू सेंड अ लीगल नोटिस, but in 138 cases it is mandatory to send a legal notice first. मैं उसकी भी आपको कंप्लायंस बताऊंगा एट अ लेटर स्टेज, बट टुडे वी आर ऑन अ लीगल नोटिस, तो वी आर सिंपली डिस्कसिंग लीगल नोटिस. तो लीगल नोटिस में क्या होता है? लीगल नोटिस में क्या होता है कि हम लीगल नोटिस किसी को पार्टी को भेजते हैं फॉर डिमांडिंग समथिंग. इट कैन बी मनी, इट कैन बी पोजेशन ऑफ अ लैंड, इट कैन बी पार्टीशन ऑफ अ प्रॉपर्टी बिटवीन द फैमिली मेंबर्स, और इट कैन बी फॉर गेटिंग डाइवोर्स. So these few are the examples of the call which we made in the legal notice. Understood, everyone?
Yes, sir.
Yes,
Sir,
sir.
like, could you explain it in a more like common way because it's like I'm not able to understand that like what it means. Other than that, we are sending something from an advocate or for a court hearing.
सपोज 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 टेल मी, अगर आपने किसी को, मेरे को सपोज आपने 50,000 रुपीज लोन दे रखा है। अब कोर्ट में क्या होता है, कोर्ट इजीली डू नॉट रिकॉग्नाइज व्हाट्सएप मैसेजेस। ठीक है, तो द फर्स्ट स्टेप आफ्टर सेंडिंग ऑल द व्हाट्सएप मैसेजेस, कॉल्स, द फर्स्ट स्टेप फॉर फाइलिंग अ सिविल सूट इन अ कोर्ट, इट विल बी द लीगल नोटिस। लीगल नोटिस हम भेजते हैं, आपने मेरे को लीगल नोट, आपने अपने काउंसिल को हायर करा, योर काउंसिल विल सेंड मी अ लीगल नोटिस डिमांडिंग सर्टेन अमाउंट। It can be 50,000 or whatever can be the amount. Including that, you can demand interest for me. Including that, you can demand damages from me. सपोज 50,000 रुपए का आपका लोन था जो मैंने आपसे ले रखा था, उस पे आपने एट द रेट ऑफ 12% आपने मेरे से इंटरेस्ट ऐड कर दिया। ठीक है, उसके बाद आपने उसमें डैमेजेस ऐड कर दिया। द अमाउंट आफ्टर एडिंग द डैमेजेस कम्स टू रुपीज 1 लाख रुपीज। So you will be demanding 1 lakh rupees from me. You can give me a time period, whether it can be 7 days, 15 days, or 1 month, or even 2 days, 3 days, depending on your basically wish, or whatever you can demand. Whatever time you can give me, it can be basically the time is not mentioned in the statute itself. The period of demand in 138 cases is only mentioned. That is 15 days in a legal notice. Otherwise, the period of demand is not mentioned. आप मेरे से चाहे 2 दिन का भी मांग सकते हो, विद इन 2 days, विद इन 5 days, विद इन 7 days, विद इन 15 days। आई एम जस्ट गिविंग यू एन एग्जाम्पल कि हम लीगल नोटिस कब भेज सकते हैं। सो एवरी वन हैव अंडरस्टूड नाउ व्हाट इज
Yes,
लीगल
sir.
नोटिस।
Yes, sir.
नाउ सपोज समवन हैज कम टू यू कि सर मेरे 1 लाख रुपए मैंने लोन दिया था एक्स को, अब एक्स इज नॉट रिटर्निंग दैट अमाउंट। सो व्हाट विल बी द प्रोसीजर? फर्स्ट यू विल टेक द इंफॉर्मेशन फ्रॉम योर क्लाइंट कि आपने लोन कब दिया था, लोन क्यों दिया था, व्हाट वाज द पर्पस। द पर्पस कैन बी फ्रेंडली लोन, बिजनेस लोन, इट कैन बी एनीथिंग। ठीक है, देन यू विल राइट डाउन एवरीथिंग कि आपने लोन कब दिया था, क्यों दिया था, और वापस कब मिलना था आपको, उस पर कोई इंटरेस्ट तो नहीं था। और उसके अलावा आप उससे पूछोगे कि डैमेजेस आपका हरासमेंट हुआ है, आप परेशान हुए, और उस अमाउंट को उसने वापस नहीं दिया तो उससे आपको कोई लॉस हुआ है। सपोज मेरे पास आज की डेट में 50,000 रुपए रखे थे, मैंने आपको लोन दे दिया, और मैंने आपको बोला था कि मुझे 1 मंथ में रिटर्न कर देना, क्योंकि मुझे 1 मंथ के बाद किसी की चीज की पेमेंट करनी है। नाउ आई नीड दैट मनी, बट यू आर नॉट रिटर्निंग दैट मनी, and due to that I am facing certain difficulties, and I took loan from someone to pay that money. So the amount which I have taken, I am paying a certain rate of interest on that loan amount, so that can be calculated as a damages, or we can calculate the damages on the basis of harassment we have faced. That can be anything, 10,000, 20,000, 50,000. ठीक है, तो our first step will be before filing the legal notice. If anyone approaches us for serving the legal notice, then we will collect the details, and we will ask all the details at a single time. ऐसा नहीं होगा कि मैं आपसे बार बार कॉल करके पूछ रहा हूँ यार तूने लोन कितने का दिया था, तूने कितने टाइम के लिए दिया था। तो क्लस्टर में पूछने के बजाय हम एक साथ उसे सारी इंफॉर्मेशन लें बिफोर ड्राफ्टिंग अ लीगल नोटिस। अब लीगल नोटिस पे किसी का क्वेश्चन है, किसी का डाउट है, यू कैन रेज योर हैंड, then I will answer everyone
Sir,
Sir,
one by
I
one,
have a doubt.
one by one. Yes, Ruhan.
So if it's legal notice, it is some condition which is some condition is very like absurd. Like you took X amount of money from me. I want it in 1 day. So sir, can it be appealed by the court?
Can it be appeal?
Can we appeal it by the court?
No. What is the appeal? You need to understand appeal क्या होती है, appeal क्या होती है, मुझे ये बताओ आप। In legal terms, what is appeal? First, you need to file your case. ठीक है, कोर्ट उस पर जजमेंट देगी। If you are not satisfied that by that decree or order, then you appeal it. Appeal is a challenge to an order.
Okay, sir. No, because, sir, my doubt is if a condition in the legal notice is very absurd, so what do we do? Do we tell the court
It
or the
is,
judge
it
that?
is, listen to me. First, what happens? If our advocate is sending a legal notice, he will make sure कि मेरी कोई डिमांड इलीगल तो नहीं है. He will make sure. He will not give you 1 day. He will at least give you 5 days, 7 days, 15 days. First thing, if any condition is absurd, then that you cannot be compelled to comply with that condition. It is not a order of a court. It is a simple legal notice, legal document which is being served to you through an advocate.
Okay, sir. Thank.
Sir,
Next, yes, Azmin,
So can you explain it once again? Your voice was breaking in between. I was not able to understand then.
what do you want to know? What do you have not understand? Tell me.
Like, sir, as we were discussing, like before the appeal, if I'm happy with everything, but there's one certain thing which the court said, like I have
नहीं
to
नहीं
do this.
पहले 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 लिसन टू मी. इसमें कोर्ट का कोई भी काम नहीं होता. The legal notice is served by an advocate. So we are not in the court. We are out of the court right now.
No, like
We will
the
go to
if
the
the
court after
lawyer.
you will listen to me first. If you will not, suppose I am sending you an legal notice. ठीक है, मैंने आपको लीगल नोटिस भेजा कि मुझे 50,000 पे करो. You do not comply with that notice. आपने मुझे नहीं पे करा, तो what remedy do I have? The only remedy before me is available that I will file a suit for recovery before the court. So it is not a legal order. It is just a legal document sent by an advocate to the other party on behalf of his client.
So basically, it's not legal. Like it's not from the government. It's just from
Yes,
one person to another.
it is from advocate. I'm telling you ना again and again. वकील नोटिस भेजता है, कोर्ट नोटिस नहीं भेजती.
ठीक है sir.
It is a legal document prepared and sent by an advocate. मैंने आपको नोटिस भेजा, आपने उसका रिप्लाई दिया मेरे को, या आपने मेरे को रिप्लाई में लिख दिया कि ये नोटिस जो आपका वो झूठा नोटिस है, तो मेरे पास रेमेडी क्या बचती है? आई कैन अप्रोच टू द कोर्ट. ठीक है, एंड आई हैव टू प्रेजेंट माय केस बिफोर द कोर्ट, एंड दिस लीगल नोटिस विल बी अ पार्ट ऑफ द डॉक्यूमेंट that prior to approaching this court I have also served a legal notice to so and so person, defendant. Now the person who files the case before the court is a plaintiff, and against whom the case is being filed is a defendant. So anyone has asked this question from me in the beginning. जो केस फाइल करता है कोर्ट में उसे प्लेंटिव कहते हैं, जिसके अगेंस्ट केस फाइल होता है he or she is the defendant. Yes, Devshri.
So I wanted to ask that the legal notices are sent for civil cases only.
Yes, the civil case, basically the legal notice is sent only for the civil cases. Like recovery, I told you in the beginning. आपको पैसे किसी से रिकवर करने हैं, आपको किसी से, आपने किसी को गुड्स डिलीवर करे थे, उसका अमाउंट आपको नहीं मिला है, या आपको डाइवोर्स केसेस में डाइवोर्स हम किसी से सीख करते हैं, या हम प्रॉपर्टी में आपने किसी को प्रॉपर्टी दे रखी है, उससे आप वापस प्रॉपर्टी अपनी मांग रहे हो, टेनेंट से मांग रहे हो, अपने ब्रदर से मांग रहे हो, किसी एक्स पर्सन से मांग रहे हो, हम तब
So
लीगल नोटिस भेजते हैं. से
sent
योर वॉइस इज नॉट ऑडिबल प्रॉपरली. So legal notice is sent only in the civil cases, not in the criminal cases. In criminal case, we filed our complaint before the police station. Yes, Aradhe?
Sir, it means that that a legal notice is not concerned with court, but sorry, it is concerned with court, but yes, the
No, no,
court
no,
has.
no. It is not concerned with the court. It is a document sent by an advocate prior to approaching the court. अभी
Yes,
तो
sir,
कोर्ट
that.
पिक्चर में ही नहीं आया, कोर्ट तो पिक्चर में बाद में
I,
आएगा.
yes, sir, yes, sir. I wanted to convey that only, but due to something like this. So it is
Yes,
basically sent by an advocate to another advocate, and the reason
right.
it carry And the reason it carries a legitimacy is because an advocate is an esteemed member of the bar, so he has some role in ensuring justice from the
Yes, 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 you can say that. And the other thing is that there are few provisions under which we need to serve a legal notice. It is 138 cases. It is mandatory to serve a legal notice. In us, before filing a suit from against a tenant, we have to serve a legal notice for handing over the possession of the suit property as per section 105 of the Transfer of Property Act. तो तब भी हमारे को लीगल नोटिस टेनेंट को भेजना होता है। ये दो कंडीशंस हैं जनरली जहां पे लीगल नोटिस को भेजना मैंडेटरी है। अदरवाइज इट इज नॉट मैंडेटरी टू सर्व अ लीगल नोटिस। विदाउट सेंडिंग अ लीगल नोटिस वी कैन प्रोसीड डायरेक्टली बिफोर द कोर्ट।
So
यस
what is
अंशिका।
the sir, what is the maximum amount of damages we can receive?
बेसिकली देयर इज नो क्वांटम टू कैलकुलेट द डैमेजेस, इट कैन बी एनी अमाउंट। जनरली लोग क्या होता है कि अमाउंट लोग कम ही मांगते हैं बिकॉज यू हैव टू पे द कोर्ट फीस। अगर सपोज मान लो मैंने आपसे 5 लाख रुपए की डैमेजेस मांग ली और आपका अमाउंट मेरे को आपसे लेना 1 लाख रुपए, तो वेदर दैट अमाउंट इज जस्टिफाइड, टेल मी।
No.
So that the amount should be justifiable and the quantum of claim you have to tell to the court also. Court will also ask from you कि आपने 1 लाख रुपए मेरे से damages मांगे या 5 लाख damages मांगे, how you have calculated that amount. So you need to justify that amount कि मेरे को ये loss हुआ है, इसकी वजह से मेरे ये damages बनते हैं. So you should always be prepared before demanding a amount of damages, and you should know on what quantum you have calculated that amount of damages. Yes, Sachi?
Yes, sir. Sir, I had a question that if I take money from someone and while taking the money, the person never mentioned that I have to return that money. So can they send me a legal notice after a few months?
Basically, everything written in the legal notice is not true. Always make sure this thing. अगर आपने किसी को पैसे दिए हैं तो there should be a reasonable time, or it's your money. Whenever you will demand that money, the X person or the other person has to return that amount. आपने मुझे अगर आज आपने मेरे को मैंने आपसे कहा यार मुझे 1,000 रुपए आपसे चाहिए, मैंने आपको मेरा आपका डिस्कशन नहीं हुआ कि मैं आपको 1,000 रुपए रिटर्न कब करूंगा, लेकिन आप मेरे से कभी तो डिमांड करोगे। देयर विल बी अ टाइम, वेदर इट कैन बी 1 मंथ, 2 मंथ, 3 मंथ, 6 मंथ। सो ऐसा नहीं होता कि हमेशा डिटरमाइंड होता है टाइम। आप लेकिन बोलोगे कि मेरा पैसा वापस करो, तो मेरे को पैसा आपका वापस करना है। अगर मेरा मन है आपको देने का, इफ आई एम विलिंग टू पे यू बैक, इफ आई एम नॉट विलिंग टू पे यू बैक, then you have to approach the court and court will decide whether I need to pay that money back to you or not. Simple है।
Okay, sir. Thank you.
Anyone else, or we can proceed further? So how to draft a legal notice? मैंने आपको पहले ही बता दिया कि आपको पहले सारा सब्जेक्ट मैटर पता होना चाहिए। यू शुड बी अवेयर अबाउट द सब्जेक्ट मैटर कि हम लीगल नोटिस क्यों भेज रहे हैं, उसका रीजन क्या है, एंड यू मस्ट शुड बी अवेयर अबाउट द लीगल प्रोविजंस ऑल्सो। अगर हम किसी को बेसिकली एक स्पेसिफिक लीगल लैंग्वेज होती है हर नोटिस के अंदर। आई विल टेक you through the legal notice also. Suppose I am sending a legal notice for vacating the suit property, vacating the property from the possession of a tenant. So I have to mention that कि आपको within 15 days you have to hand over the peaceful vacant possession. उसके अलावा you did not tender the rent. आपने इस पीरियड से इस पीरियड का रेंट मुझे दिया या नहीं दिया। अगर आपने डैमेजेस उसमें करे हैं तो यू नीड टू पे फॉर द डैमेजेस। So take proper instructions from your client. What is the subject matter? What is the information? And you must be aware about the legal provisions before demanding the money. Understood? In 138 cases, you cannot demand the money back in 7 days. You can only you have to give the fixed period of 15 days in the legal notice of 138 cases. That is check bounce cases. अगर आप check bounce का किसी को notice भेज रहे हो तो you have to mention 15 days. Otherwise, that notice is invalid, and your case cannot stand on his legs before the court. Understood? I have already told you, ask questions in cluster rather than running to the client for every problem. Understand the client's perspective and the dispute involved thoroughly. Request samples if available for better understanding. Draft the legal notice with ability to make changes as required by the client. सपोज मैंने लीगल नोटिस ड्राफ्ट करा तो आई शुड सेंड यू द लीगल नोटिस फर्स्ट, कि आप मुझे बता दो इसमें आपको कोई प्रोविजन, मतलब कोई आपको चीज मेरी जो मैंने डिमांड करा है, इफ यू फील लाइक दैट देयर इज सम करेक्शन इन द डाटा विच यू हैव प्रोवाइडेड टू मी। सपोज आपने मुझे 1 लाख बताया था, मुझे लगा कि आपने मेरे को 10 लाख बताया था, तो आई मेंशन 10 लाख, सो यू विल करेक्ट दैट अमाउंट। So understand the specific requirement of each section with facts and relief requiring specified and the grievance section needing clarity। तो आपको पता होना चाहिए कि आप 15 डेज में ही उससे डिमांड कर सकते हो, उससे पहले नहीं कर सकते। और मेक श्योर यू डू नॉट कमिट अ मिस्टेक बिफोर सेंडिंग अ लीगल नोटिस, बिकॉज आफ्टर गोइंग टू द कोर्ट यू कैनॉट रेक्टिफाई योर नोटिस। You have to rectify your notice after sending the legal notice within 7 days, and we call that document a corrigendum. इट इज नॉट मेंशन इन द स्लाइड, आई एम टेलिंग यू फ्रॉम माई एक्सपीरियंस कि अगर आपने लीगल नोटिस में कुछ गलती करी है तो यू हैव टू करेक्ट दैट मिस्टेक विद सेंडिंग अ कोरिजेंडम। यस सर, आदे।
सर मैं तो जनरली पूछना था, मुझे ऐसे ही दिमाग में मेरे क्वेश्चन आया कि सर जैसे
आस्क।
हमें जैसे पता है कि लीगल नोटिस जब भी ड्राफ्ट होता है इट इज ड्राफ्टेड ऑन अ स्टैम्प पेपर, जो
नो
कि
नो, हु टोल्ड यू इट इज ड्राफ्टेड ऑन अ स्टैम्प पेपर? लीगल नोटिस
मतलब
इज नेवर ड्राफ्टेड ऑन अ स्टैम्प पेपर, इट इज ड्राफ्टेड ऑन अ लेटर हेड ऑफ अ एडवोकेट, not on a stamp paper. On a
वो
stamp paper, we draft a MOU, deed, memorandum of undertaking, understanding, rent agreement, partnership agreement. All these legal documents are drafted on a stamp paper, not legal notice. Understood?
ओके सर, ओके।
Yes. Yes, Aina Srivastav.
So you said that the client asks you to make changes if there are some. That means the client has full control over the legal notice.
If suppose you hired me, आपने मुझे
Yes.
बोला कि सर मेरे मेरे को यार कोई भी XYZ रीजन है, send that person a legal notice. So I drafted a legal notice. For approval, I will send. It is my duty to send you that legal notice before dispatching that legal notice to the person whom we are sending that notice. So I will send that notice to you. You will go through that notice, and if you found something which is not correct, it can be amount or any date, because there can be multiple dates. Suppose आज मैंने आपको 1,000 दिए, कल मैंने आपको 10,000 दिए, परसों मैंने आपको 1 लाख दिए, so we will be demanding 10,000, 1,000, everything in that notice. So there can be correction of the date. So first I will take the approval from the client, then I will dispatch that notice to the person whom we have addressed that notice. Understood?
Okay. Yes, sir.
So what will be the contents of a legal notice? So on the top we will mention the date, correct name and address to whom we are sending the legal notice. Then we will mention the subject, we will mention the basic facts, then we will mention the dispute, and thereafter we will mention the requisition or compliance that we call it as a call, which is mentioned in the last of the legal notice. Ki, therefore we call you to return this amount within so and so period. Otherwise, failing which, you shall be liable to be criminally prosecuted before the court. Criminally or civil. It can be anything before appropriate court of law. Everyone has understood now? Yes, Ruan, say.
Yes.
Sir, I just wanted to ask,
Yes.
sir, if something is not, if something is just verbally agreed, sir, can that also be considered as a type of contract? If something is only verbally agreed.
Yes, yes, definitely. Under section 91 of the Indian Contract Act, you will found this about oral contracts.
Sir, but if there is no proof that this agreement was
Suppose,
approved by both the
yes,
parties,
yes.
then
Suppose आपने मुझे 1,000 रुपीज कैश में पे करे थे, ठीक है? अब नाउ यू हैव पेड मी इन फ्रंट ऑफ रूहान. रूहान कैन बी द विटनेस टू प्रूव दैट ओरल एग्रीमेंट,
okay, sir.
or we can make 2-3 witnesses. So it is difficult to prove your basically demand if there is no legal document to it. But suppose आपने मुझे अकाउंट ट्रांसफर करा था, so we can prove that you have transferred the amount to me, and I have not returned that amount to you through the bank, then you can approach the court that, see, so and so date, in front of Ruhan I have paid money to Sachin, but now he has refused to return that amount back. Or there can be a situation I have returned that amount to you in cash also. So now I will bring the witness before the court. See, in front of these witnesses, I have returned on so and so date the entire amount. So we call this oral agreement,
Sir,
which is
for
mentioned in the
example,
section 99 of the Contract Act. Yes, say.
so for example, I have transferred you money through the accounts, and you have paid cash back to me, and there was no witnesses, and I again say that you have not paid me the money. So who
Hmm.
would be liable for this?
Yes, definitely. If I am not able to prove that I am not paid you the money back, so
Hmm.
I will be liable to pay the money back to you through the order of the
Then,
court.
okay, sir.
Yes, Aina.
So, for example, a client comes to me and say that I gave 1 lakh rupees in cash to someone, but he did not have any witnesses. Then, how we will draft the legal notice?
Sorry, come again.
If somebody comes to me and say that I gave 1 lakh to the person in cash, but there were no witnesses, then what would we do in that situation?
So this is the thing ना, कहते हैं ना कानून अंधा है, कानून को दिखाना पड़ता है ना. अगर आप दिखाओगे कानून को तभी आपको ऑर्डर मिलेगा इन योर फेवर, अदरवाइज यू विल नॉट गेट द ऑर्डर इन योर फेवर.
Okay, understood, sir.
Yes, you need to prove your case before the court. If you are not able to prove the case before the court, then you cannot win your case before the court.
Got it.
Now I will show you some example of the notice. Before going ahead, give me a moment. I am searching for a notice for you. I will show you two documents before proceeding further. One is legal notice, the other is reply. My screen is visible to all.
Yes, sir.
So this is the legal notice, ठीक है, which I have sent to someone on behalf of my client. So this is my letterhead. ठीक है, सचिन अग्रवाल, enrollment number, my details, personal details. Now on top we have mentioned date. ठीक है, this is legal notice to the person we have addressed this notice. This is a company called Thoucentric Technology Private Limited. If we mention if the addressee is a company, then we need to mention through director AR chairman. ठीक है, through its director AR or chairman. It's registered office. This is the office. Now this is the instructions. Under instructions of from and on behalf of my client so and so so and so, I do hereby serve you upon the following legal notice. ठीक है. Now I have mentioned about the details of my client. So these are the brief facts कि हमने आपके साथ करा था काम. You that it is pertinent to mention that my client and you, the addressee, entered into an agreement dated so and so, wherein it was agreed that my client will provide you the services of lead ABAP consultant to you, the addressee. These are the basic details. ठीक है. That initially it was agreed that you will pay 28 lakh rupees for the services provided by my client, but during the period of agreement you, the addressee, asked for further changes. ठीक है, ये उसके एडिशनल 8 लाख रुपीज हो गए. तो उसके बाद नाउ कम्स टू द डिस्प्यूट that that as per the para number 8, that as per the agreement scope of work so and so for the changes requested by you, the addressee was liable to make the payment of 36 lakh, out of which you, the addressee, have paid an amount of 14 lakh 40,000, and now the addressee is liable to pay an amount of rupees 21 lakh 60,000. That my client wrote various mails to you. These are the dates of the mail, but you did not reply to those mails. ठीक है, that you, the addressee, is liable to make the payment amounting to rupees so and so to my client for the services provided to you, the addressee. That the aforesaid amount is being amount is being used by you, the addressee. उसके बाद मैंने इंटरेस्ट मांगा हुआ, यू कैन सी 18% अपार्ट फ्रॉम डैमेजेस. ठीक है. And this is the last paragraph, which is most important in the notice. That is, we call it as a call, which is being made in the notice. So I therefore call upon you, the addressee, to immediately make the payment of rupees 21 lakh 60,000 along with interest 18% within 7 days from the date of receipt of this notice. Failing which, my client shall have no option except to initiate legal proceedings against you, the addressee. Who is the addressee? The person whom we have addressed this notice. He is known as addressee or noticee, we can call him. ठीक है, in the competent court of law, you are further called upon to pay the legal charges for sending this notice. Now I have digitally signed this notice. ठीक है, everyone is everything is clear to everyone now.
Yes, sir.
If
Yes, sir.
anyone has any doubt,
Sir,
otherwise I can proceed
Yes,
to the
sir.
reply also. So now we will start with the reply. If someone sends you the notice, so how you will reply to that notice? So this is the reply. So basically, reply to legal notice dated so and so. This was the reference number mentioned on the notice, which have been served to my client. ठीक है? To Anshuman Gargesh, he is the advocate. Chamber number so and so, 30,000 report. My client Nitin Chaudhary, director of so and so, has placed the legal notice dated so and so, which you issued on behalf of your client so and so so and so. ठीक है? With the instructions to reply the same. ठीक है? Understood? So उसके बाद क्या है? अब हमने क्या लिखा हुआ है कि एट द आउटसेट इट इज स्टेटेड दैट योर क्लाइंट्स हैज नॉट डिस्क्लोज द ट्रू एंड करेक्ट फैक्ट्स even before you by leveling such allegations against my client. It seems that your client wants to extort hard earned money from my client. So these are the legal paragraphs we mentioned in the reply. ठीक है, उसके बाद आ जाएगा दिस वी कॉल पैरावाइज रिप्लाई. उसके बाद ये हमने बेसिक डिटेल्स डाली हुई है नोटिस के अंदर, जो हमें रिप्लाई दे रहे हैं उसका, कि दैट द नोटिस अंडर रिप्लाई इज ड्यूली रिप्लाइड बाय माय क्लाइंट नेमली नितिन सो एंड सो बीइंग डायरेक्टर ऑफ सो एंड सो. ठीक है, ऑन बिहाफ ऑफ इट्स एम्प्लॉय, बिकॉज दिस नोटिस वाज एड्रेस टू द डायरेक्टर ऑफ द कंपनी एज वेल एज टू द एम्प्लॉय. तो मैंने ये लिखा हुआ है कि मैं इस नोटिस का रिप्लाई आपको ऑन बिहाफ ऑफ डायरेक्टर भी दे रहा हूँ, ऑन बिहाफ ऑफ द एम्प्लॉय भी दे रहा हूँ, हु इज किरण भंडारी, and she is working under my client and discharging her obligation as per the needs of the organization. So she cannot be held personal liable because she is working for the company. ठीक है, that it is pertinent to mention that my client has never used any video content. So these are the facts which I mentioned. Now coming to the para-wise reply. So suppose first para में क्या होता है कि there are basic detail. Give me a moment. 1 second. So coming back, पैरा वाइज रिप्लाई. सो हमें पैरा वाइज एक एक पैरा का रिप्लाई देना होता है. पैरा वाइज में एक एक चीज डिटेल में मेंशन करनी होती है और मना करनी होती है. तो पैरा वन क्या था नोटिस का? सपोज इट वाज अ लीगल इंफॉर्मेशन कि मेरा क्लाइंट ये है, वो ये करता है, तो वी डोंट हैव एनी डिस्प्यूट टू दैट. सो वी हैव एडमिटेड दैट पैरा कि दैट द कंटेंट्स ऑफ पैरा नंबर सो एंड सो मैटर ऑफ रिकॉर्ड हेंस नीड्स नो रिप्लाई. ठीक है, अब सेकंड पैरा में ही मस्ट हैव मेकिंग एलिगेशंस, लेवलिंग एलिगेशंस अगेंस्ट अस, सो वी हैव डिनाइड. सो जो भी हमें लगता है कि झूठ है, वी विल डिनाई दैट, एंड जो हमें लगता है ठीक है, वी विल एडमिट दैट. सो वी हैव मेंशन एवरीथिंग अकॉर्डिंग टू दैट. उसके बाद क्या होता है? सपोज these are the submissions given by me that my client have a significant social media presence with a community of more than 1.45 lakh followers on Instagram, but still my client is open to resolve the matter amicably. So these are the submissions given on behalf of my client for the allegations level on behalf of the other party. So these are the allegations only. Now this line is also very much, para is also very much important because we have mentioned contents of the call of your notice are vague, false and illegal. I therefore on behalf of my client suggest you to give advice to your client to withdraw the notice under reply, and further ask your client to refrain himself and his agent from contacting my client. And if your client will take any step action against my client on the basis of a false and frivolous notice under reply, The same shall be dependent by my client only on the cost and risk consequences of your client, which please note, I therefore on behalf of my client further suggest you to ask your client to refrain himself from leveling false and frivolous allegations. This is the call made by me कि आप ये चीजें करो, नहीं तो मैं आपके अगेंस्ट एक्शन लूंगा कोर्ट में. Now I have signed, I have mentioned that copy has been kept for the further record in my office. Then I have signed to the notice. This is the reply. So anyone has question regarding the reply? You people can raise your hand. So now we have discussed regarding the notice and reply. अब किसी के दिमाग में कोई भी क्वेश्चन हो, you can ask me.
सर तो जैसे ये सारे नोटिस के कंटेंट होते हैं, सो आर दोज लाइक मतलब जैसे आप ड्राफ्ट करते हो तो आपको पता कैसे चलता है कि वी नीड टू कीप अ रिकॉर्ड ऑफ दिस मतलब अगर आपको एक चंक मिलेगा डेटा का, तो आपको इसमें से कैसे पता चलेगा कि हमें इन इन पॉइंट्स को लीगल नोटिस में कवर करना है?
अब मैंने आपको बताया ना कि क्लस्टर में आपको इन्फॉर्मेशन लेनी पड़ेगी अपने क्लाइंट से. यू हैव टू राइट इट डाउन, नहीं तो आपको याद ही नहीं रहेगा. इफ यू आर टेकिंग इन्फॉर्मेशन फ्रॉम मी ऑल्सो, अगर आप मेरे से कुछ पूछ रहे हो, सपोज आई एम टेलिंग यू 10 थिंग्स, तो हाउ यू विल ग्रास दैट डिटेल्स which I have provided to you? You will write down somewhere. So whenever you are meeting a client, you are taking brief from your client, so आपको details अपने पास mention करनी पड़ेगी, उनसे documents लेने पड़ेंगे. On the basis of the details or the information provided to you by your client, you will proceed further accordingly.
Got it, sir. Got it.
Anyone else has any other question regarding to the notice or reply? You can ask me. Chalo, now we will proceed to will. Can anyone tell me what is will? Will क्या होती है? Who will tell me?
Sir, it is a document which suggests the distribution of assets and liabilities and
Not
personal.
suggest. It do
मतलब
not
sorry,
suggest. Yes.
it mentions
Yes.
the
That after the death of the executor, his property or estate, in what proportion or what manner it will be distributed, either among the legal heirs, or it can be mentioned that the property may be given to a trust or anyone else also. Yes, Suhana?
सर आई वांट टू आस्क अबाउट कि कितने पेजेस का होना चाहिए लीगल नोटिस?
लीगल नोटिस ऐसा नहीं. लीगल नोटिस 2 पेज का भी होता है, लीगल नोटिस 4 पेज का भी होता है, लीगल नोटिस 15 पेजेस का भी होता है, डिपेंडिंग ऑन द कंटेंट यू वांट टू मेंशन. अगर आपका सिंपल रिकवरी का केस है अमाउंट का, तो आप व्हाट यू विल मेंशन इन दैट कि मैंने पैसे कब दिए थे, आपने पैसे वापस देने के लिए कब कहा था, मैं आपसे इतने दिन से फॉलो अप ले रही हूँ, बट यू आर नॉट. Basically, first you promise me that within 1 month you will return my amount. Then again I approach you after 1 month. Then you again give me that right now my condition is not good. Again I need some time. So ये सारी details notice में आती है. It can be 2 page, 3 page, 6 page, 10 page or 15 page. Understood?
Yes.
Yes. Anyone else? Yes, Rohan.
Sir, I wanted to ask in the earlier no, in the earlier legal notice that you showed us, sir, it showed that the client or that your client contacted the addressee who needed to pay the money. So, sir, is it necessary for us to notify them that you have to pay, or can we just pursue legal action without any notices?
नहीं, I told you ना कि there are few cases where you need to serve a legal notice. It is the case of 138 check bounce, and the other case I told you about the termination of tenancy. So these two are the condition when you need to supply the legal notice. Otherwise, without serving the legal notice, you can proceed directly through the court.
Okay, sir.
Okay. So now, what is will? Will deed. In Indian law, a will deed or simply a will is a legal document outlining how a person wishes their assets and property to be distributed after their death. It is a written declaration of a person intention regarding their property intended to be carried out after their death as defined by the Indian Succession Act 1925. तो विल कब एनफोर्स होती है, और मुझे कोई बताएगा विल कब एनफोर्स होती है, और विल कितनी भी बनाई जा सकती है या विल एक ही बनाई जा सकती है? यस चारू?
Sir, will can be made once and it can be edited, I guess.
सॉरी?
The will can be made once and it can be edited by the person who made it.
बेसिकली फर्स्ट, जरूरी नहीं है विल, विल कोर्ट, कोर्ट विल नहीं बनाती। will is made by a person. It can be handwritten also, it can be typed also। पहला फॉर्मेट तो ये हो गया आपका, आपने हैंड रिटन एक विल बना दी। विल में क्या जरूरी होता है? विल में नीचे दो अटेस्टेशन जरूरी होती हैं, दो विटनेसेस जरूरी होते हैं, और जो विल बना रहा है उसके सिग्नेचर जरूरी होते हैं। पहली बात, एक सिंपल पेज पे भी आप अपनी प्रॉपर्टी का मेंशन करके आप नीचे दो विटनेसेस से अटेस्ट करा के उनके सामने और अपने साइन करके, दैट इज ऑल्सो अ वैलिड विल। फर्स्ट। second the way we can execute the will is that कि it can be executed by a deed writer। Thereafter we can apply before the sub registrar, not before the court। सब रजिस्ट्रार जहाँ पे प्रॉपर्टी के डॉक्यूमेंट्स एग्जीक्यूट होते हैं, रजिस्टर होते हैं, वो बिल को रजिस्टर करता है अपने पास, और अब उसके सामने सारे साइनिंग होती है, उसके सामने विटनेस की जो वीडियो रिकॉर्डिंग होती है, फोटोज क्लिक होती हैं। सो दैट मेक्स द बिल मोर ऑथेंटिक। बिकॉज सपोज कोई बंदा मर गया, अब कोई मर गया, उसके बाद उसकी विल किसी ने लिख ली, घर पे ही बना के उसके साइन करवा लिए पहले ब्लैंक पेपर पे। सो इट इज मोर डिफिकल्ट to identify whether that will is genuine or not। so it's better to get your will registered। ठीक है, मैंने अपनी एक विल बना ली और विल को मैंने कोर्ट में जाके सब रजिस्ट्रार के पास जाके रजिस्टर करा लिया, तो नाउ दैट विल बिकम मोर ऑथेंटिक। कोर्ट उस पे क्वेश्चन कम करेगी एज कंपेयर टू अनरजिस्टर्ड डॉक्यूमेंट। यू ऑल पीपल मस्ट हैव heard about the case which is right now going on about संजय कपूर, करिश्मा कपूर केस। पता है कि
Yes,
सबको?
sir. Yes, sir.
तो उसमें
Yes.
क्या हुआ है, उसमें यही हुआ है। उसमें क्या हुआ है कि प्रिया कपूर वॉज द करेंट वाइफ ऑफ संजय कपूर। उसने क्या करा, या उसने, हमें नहीं, वी कैनॉट से राइट नाउ बिकॉज द मैटर इज सब्जुडाइज बिफोर द कोर्ट, बट उन्होंने एक विल प्रेजेंट करी है कोर्ट में कि संजय ने ये विल लिखी थी, संजय कपूर ने, और उसमें सारे एसेट्स उसने मेरे को दे दिए हैं। अब नाउ दैट विल इज नॉट रजिस्टर्ड। so everywhere that will is being questioned and the will is very much skeptic also। सब उसको शक की निगाहों से देख रहे हैं, किसी को नहीं पता whether that will is genuine or not। so this is the purpose of getting the will registered। there is one more way to make that registered will more authentic, that is probate, which you will come across at a later stage when you will practice before the court। so probate में क्या होता है कि कोर्ट में आप फाइल करते हो कि मेरी ये विल है, इसको मुझे प्रोबेट कराना है। इट कैन बी रजिस्टर्ड विल ऑल्सो, अनरजिस्टर्ड ऑल्सो। प्रोबेट में क्या होता है, जो आपके दो विटनेसेस हैं, व्हाट इज रिक्वायर्ड टू प्रूव अ विल, द टू विटनेसेस हु हैव अटेस्टेड द विल need to appear before the court। yes, in front of me this will was executed by so and so person। अगर दो विटनेस आके कोर्ट में अपने एग्जामिन होते हैं और अपने कोर्ट में स्टेटमेंट देते हैं, तो विल में क्या होता है, प्रोबेट हो जाता है। उसके बाद यू कैनॉट चैलेंज दैट विल। दैट इज द एंड thing which we can do to make our will more authentic, to get our will probated। understood everyone? what are the key aspects of a will deed in Indian law? पर्पस क्या होता है? पहली बात तो किसी ने, मैं आई एम कमिंग बैक टू द थिंग दैट समवन हैज आंसर्ड, दैट विल एक ही बार बनती है। जब तक मैं जिंदा हूं मैं रोज विल बना सकता हूं, मैं हर महीने विल बना सकता हूं, मैं कितनी भी विल बना सकता हूं, बट द लास्ट विल प्रिवेल ओवर ऑल द विल्स। जो मैंने लास्ट विल लिखी होगी अपनी, वो प्रिवेल करेगी जितनी भी पुरानी विल्स है उसके ऊपर। चाहे मैंने 100 विल बनाई हो और लास्ट में मरने से पहले एक दिन पहले एक विल बना के गया हूँ, दैट इज 101 विल। इट विल प्रिवेल ओवर 100 विल। ऑलवेज रिमेंबर दैट। जो भी आपकी लास्ट विल होगी वो प्रिवेल करेगी ओवर ऑल द अदर विल। चाहे पुरानी रजिस्टर्ड भी होगी ना, तो भी आपकी जो 101 वाली विल है, दैट विल प्रिवेल ओवर दैट रजिस्टर्ड विल। यस स्वेच्छा?
So I had a question. तो
यस
मैंने
यस
केसेस
आस्क।
में ये होता है कि जो पर्सन है जिसने विल बनाई है उसकी डेथ हो जाती है, और जब विल रीडिंग होती है तो काफी लोग कंटेस्ट भी करते हैं, और केस में वो ये कहते हैं कि वो मतलब मे बी वो पर्सन मेडिकली फिट नहीं था, वो अपने राइट सेंसेस में नहीं था। सर
That
अगर
is
द
the
थिंग
thing. That is the thing. We challenge that will. That is the reason for getting your will registered and probated. अगर सपोज अभी यही हो रहा है प्रिया कपूर के केस में, she has presented a will. Why she has presented the will? Because Karishma Kapoor and the mother of Sanjay Kapoor has filed a case for partition of the property. Then she has presented the will that see the entire estate of Sanjay Kapoor has been given by Sanjay Kapoor to me, and this is a legal document, that is will. Now Priya Kapoor, that by Karishma Kapoor and the mother of Sanjay Kapoor has challenged that will. कि see this will is not genuine. If अगर वो will registered होती और probated होती, तो कोर्ट उसको मतलब इस बात को ज्यादा कंसीडर करता है कि विल जेन्युइन है. अब नाउ द विल इज नॉट रजिस्टर्ड, सो कोर्ट इज लुकिंग दैट विल इन अ मोर skeptic manner. Yes, Sachi?
Sir, if a person X has a will and they have registered it, but then they want to edit that will and they make another will, but they die before registering it. So, which one would prevail?
I told you na कि last will prevail over all the wills, whether it is probated or any probated or not. The last will prevail over all other will.
Even if
Always
it is
remember
not
that.
registered.
Yes. It is not required under law. In Delhi, there are numerous number of judgments that registration of will is not mandatory.
Okay, sir.
Only the mandatory thing, if you will go through the section, I think 69 and 70 of Indian Evidence Act, you will found the section, it has been mentioned that will can be proved through witnesses. अगर एक विटनेस मर गया तो जो एक विटनेस बचा है, he will appear before the court and he will give his statement कि yes, the will was executed in front of me, everything has been mentioned, written in the will has been written or has been written with the consent of the executor of the will. So that will prevail over all other wills. Anyone
Sir, if
else?
both the witnesses
so
die,
sir,
If yes, good question. If both the witnesses die, then there is another way to prove that will. First, the registrar. If the will is registered, then the registrar will appear before the court or anyone else. Generally, registrar do not appear. His record keeper appear before the court and he files the record that yes, this so and so will was registered in front of me. First thing. The other way, if both the witnesses have died, then we need to summon the writing of the witnesses. It can be from the bank of the witness to examine that the signature of both the witnesses are same. The attesting witnesses of the will and the person who have identified, attested the will, his signature in the bank accounts are same. His writing is same. Then the court will consider it as a valid will. Understood, everyone?
Got it.
yes, sir.
So now we will discuss legal validity. For a will to be legally valid, it must meet certain requirements, including the testator, the person making the will must be of sound mind and at least 18 years of age. This is a general condition. 18 साल के बाद ही he can make a will after attaining the age of majority. And the other thing is that he must be of sound mind. The will must be written and signed by the testator. The will must be attested by two or more witnesses. If the will has only one witness, always remember this, that will is invalid. दो विटनेस मैंडेटरी है अटेस्ट करना विल को. Now we will discuss about how we can revoke a will. A will is revocable, meaning the testator can change or revoke it at any time. Execution: a will takes effect after the death of the testator. Registration: while registration of a will is not mandatory, it's advisable and can help avoid future litigation and disputes. For telling you for a reference only, recently I visited the office of a Delhi High Court retired judge. He has basically affixed the painting in his office. He has mentioned in the painting that where there is a will, there is a dispute. Always remember this. Where there is a will, there is a dispute. So to avoid all the disputes, generally it is advisable to get your will probated. Challenging a will. Even registered wills can be challenged in court under certain circumstances, such as lack of mental capacity, undue influence, or fraud. Anyone have any question about the will, or we should proceed further?
Got it, so they will think.
Sir, we can proceed.
Yes, Aina.
So what if that person didn't wanted any witnesses, but he still registered the will and he died?
Am I audible?
Yes, sir.
Yes, Aina. Can you ask me
Yes, sir,
again
you're audible.
due to some network issue?
Sir, can you hear me now?
Yes, I can hear you.
I was saying that what if the person who wrote the will died before getting the witnesses?
So that will is not valid. I told you na.
Okay.
Will is only valid or complete when you get it attested by two witnesses. Otherwise, there is no sanctity of that will. It will not consider to be a valid will. Understood?
Okay.
Now we will discuss about what is gift. Gift deed in India. So in India, gifts are governed by the TPA Transfer of Property Act. A gift of a property involves transferring the ownership of one's property to another person through a gift deed. The gift deed is a document that contains all the provisions relating to the gift. The person gifting her property is called donor, and the person accepting the gift is the donor. For a gift to be legal and valid, the donor must voluntarily gift transfer the property to the donee without any consideration. That is, the donor should not receive anything from the donee for making the gift. The donee should accept the gift within the lifetime of the donor or for the gift to be legally valid. अब मैं आपको क्लियरली बताऊं व्हाट इज गिफ्ट. गिफ्ट क्या होता है? सपोज आपने मुझे कोई गिफ्ट दिया, बट अगर वो गिफ्ट मोर देन वैल्यू ऑफ 100 रुपीज है, सो इट मस्ट बी डन थ्रू अ रजिस्टर्ड डॉक्यूमेंट, रजिस्टर्ड गिफ्ट डीड. अगर 100 रुपीज से कम है, देन ओनली यू कैन एक्सेप्ट दैट गिफ्ट. Otherwise, you need to get that gift deed attested by the sub registrar after paying the stamp duty. Understood everyone? गिफ्ट क्या होता है मैंने आपको क्लियरली बता दिया. कोई भी किसी को गिफ्ट देता है, फर्स्ट ऑफ ऑल कोई कंसिडरेशन नहीं होना चाहिए. और गिफ्ट देने से पहले अगर 100 रुपए से ज्यादा का गिफ्ट होता है, इट मस्ट बी रजिस्टर्ड बिफोर द सब रजिस्ट्रार. और वन मोर थिंग, अगर मैंने आपको गिफ्ट दिया है तो यू नीड टू एक्सेप्ट इट ड्यूरिंग माई लाइफ टाइम. Otherwise, it will not be called a complete gift, complete transfer of gift. The gift must be registered with the registrar or sub-registrar office for it to be recognized under the law. The transfer of the donor to the donee takes place immediately, and the parties need not go to the court for its execution. ये सब रजिस्टर के पास होता है, not before the court of law. Clauses in gift deed. Details of donor and donor. The gift deed should mention the name,
Sir, your
address, and
voice is
relationship between
breaking.
the donor and donee.
Sir, your voice is cracking.
A lot.
Now my voice is audible to all.
Sir, it's still cracking.
Now my voice is audible to all.
Yes, sir.
Sir, you're audible.
So yes, these are the clauses which are mentioned in the gift deed. Details of donor and donee. The gift deed should mention the name, address, and relationship between the donor and donee. The consideration amount. The gift deed should mention that the donor is transferring the gift property out of love and affection towards the donee, and there is no consideration of any other type involved in the transfer. Must be made out of free consideration without consideration amount. Otherwise, that gift is not valid. Then the other clause is voluntarily transfer. The gift deed should mention that the donor is voluntarily and freely transferring the ownership of the gift property to the donee. The transfer shall be free of any fear, coercion, or threat. Ownership of property. The gift deed should mention that the property is in existence and the donor is absolute owner. Suppose I am gifting you something for which I am not the owner, so that cannot be a call a valid gift. And the donor has delivered the possession of the gift property to the donee. It is very much important that the possession must be delivered. Suppose I am gifting one car to my son. ठीक है, तो फर्स्ट आई नीड टू गेट इट रजिस्टर्ड कि मैं इसको ये गिफ्ट दे रहा हूँ. इट शुड बी आउट ऑफ लव एंड अफेक्शन and the possession of that gift to be delivered to my son for it being a valid transfer and for gift deed. Property details. The gift deed should specify the detailed description of the gift property. The rights of the donee. The gift deed should mention the rights of the donee. It includes the right of the donee to enjoy the property peacefully and sell or mortgage or lease the property. Acceptance by donee. The gift deed should mention that the donee accepts the gift of the property. Property detail. The gift deed should specify the detailed description of the gift property. Rights of the donee. The gift deed should mention the rights of the donee. It includes the right of the donee to enjoy the property peacefully and sell or mortgage or lease the property. Acceptance by donee. The gift deed should mention that donee accepts the gift of the property. Delivery. The gift deed should mention the intention of delivering the possession of the gift deed expressly or impliedly. Now everyone has understood about the gift. What is gift deed?
Yes,
Yes,
sir.
sir.
किसी का कोई डाउट है?
No, sir. No, sir.
In the next class, we will be discussing about your assignments because today we were short of time due to which we were unable to discuss your assignments. So on the next date, next session, we will discuss. First, we will discuss about all your assignments. Then we will proceed further accordingly.
Okay, sir.
Sir, I have a doubt.
Yes, ask.
I was actually not keeping well, so how many assignments have you given by now?
I have given only one assignment up till now.
Where can I get it?
You are not aware about the assignment.
No, sir, I was not keeping well.
Basically, in the last session taken by me, I have given assignment that you need to write an essay. You can take any law. ठीक है, आप सपोज यू टेक अ लॉ रिगार्डिंग टू द डेफेमेशन पे आपने लिया. यू नीड टू मेंशन दैट वेदर दिस लॉ एट द प्रेजेंट स्टेज इज फुलफिलिंग इट्स ऑब्लिगेशंस या और वेदर इट इज आउटडेटेड और इट नीड्स सर्टेन चेंजेस. तो आपको ये मेंशन करना है कि कोई लॉ यू कैन टेक एनी लॉ एनी जो आज की डेट में यू फील दैट लॉ इज आउटडेटेड और उसको चेंजेस की जरूरत है, तो उस लॉ के बारे में आप बताओगे वो आउटडेटेड क्यों हो गया. You need to mention that and you need to suggest the changes which can be made in that law to make it more useful in the present circumstances, present time.
Okay, sir.
So anyone has any question now, or we can wind up this session?
No, sir.
Sir, I wanted to ask one question.
Yes, ask.
Sir, if a law student who is currently in college or something pursuing law, can he or she write legal notice? And if
No, how you will, in what capacity you will write a legal notice? Tell me.
sir, your voice is not clear.
I am asking you in what capacity you will write a legal notice. You are not an advocate. How you will write a legal notice? You cannot write a legal notice. One more thing I
Okay,
want
sir.
to ask from you all, see whether any of you have attended the court virtually up till now. You have been provided with the links of the court.
No,
sir.
sir.
So
No,
what I
sir.
will do, I will provide you a link of the court. And nowadays the courts are working partially. तो यू नीड टू टेक केयर कि कब से कब कोर्ट फंक्शनिंग है, क्योंकि जनरली क्या हो रहा है ना कि अभी पार्शियल वर्किंग डेज हैं तो दे हैव चेंज द नेम। पहले क्या होता था, दीज आर वेकेशन बेंचेस, रादर देन कॉलिंग देम एज अ वेकेशन बेंचेस दे हैव नेम देम एज अ पार्शियल वर्किंग डेज। तो उसमें क्या होता है कि कम जजेस बैठते हैं, ओनली 4 5 judges are sitting and taking only urgent matter which are urgent. Urgent relief is required in the matter that is only taken up by the judges. So we will provide you a link also. What you will do, you will install WebEx. Through that link you will install the software and you can join the link, but make sure that your mic is off and your video is also off. You can basically see the entire proceedings going on in the court, but make sure you do not turn on the mic and do not turn on the video. After watching the court proceedings for some time, you can leave the proceeding, and if you have any question, then I can answer you. In the next session, we will do that. I will provide the link to everyone. You guys can go through that. Basically, join the link, join the court proceeding through that link. Understood?
Sir, when will it be shared?
I will share with you today only. Don't worry.
Okay, sir.
Fair enough, sir.
Yes, Aina.
Sir, the essay that you told to write is practically we have read on a single law, na, that is very
Yes,
outdated
yes,
now.
definitely on a single law.
Okay, okay.
Chalo, good evening, guys. Thank you very much.
Thank you, sir.
Thank you, sir.
I'll end the
Thank you,
session
sir.
now. So thank you so much for another wonderful session in the
Most welcome.
law internship. I'll end the session now. I hope most of your doubts were cleared. And if there's any other issue, please let me know on our WhatsApp group. So goodbye, everyone.
Thank you,
Bye,
sir.
sir. Bye. Thank you, sir. Bye, sir.
Thank you, sir.